Okay, and with that, welcome from Phoenixville Public Library. I'm Mark Pinto, the Adult Services Director here, and we're pleased to have with us tonight Brian Doyle from Legal Aid of Southeastern Pennsylvania to speak about civil protection orders during this Domestic Violence Awareness Month. Brian, thanks so much for joining us tonight, and go right ahead and take it away.
Thank you for the invitation, Mark. Again, my name is Brian Doyle. I'm a staff attorney with Legal Aid of Southeastern Pennsylvania. I've been there for about 10 years. I do protection orders, I do child custody, unemployment compensation, and I'm the pro bono coordinator, so I try to get attorneys to volunteer their time. Legal Aid is a 501c3 private nonprofit legal services organization. We provide legal advice, direct representation, and then workshops that help clients deal with their civil legal issues. Some of the types of cases we help with are, like I said, protection from abuse and child custody. In addition to unemployment compensation, we do public benefits appeals work, so SNAP, cash assistance, Social Security benefits. We do landlord-tenant representation. We do limited estate planning, powers of attorney, simple wills, consumer issues like bankruptcy, debt collection practices, and then there's always more that come to me later after I've rattled off my list. So we're the collar counties around Philadelphia. I'm in the Westchester office for Chester County. We also have offices in Montgomery County, Delaware County, and Bucks County. So just to launch into the presentation itself, I'm going to start with the protection orders in general, because they have a lot of things in common, in particular the Protection from Abuse Act and the Protection from Sexual Violence and Intimidation Act. And then I'm going to talk more in detail about each particular law and what the court needs to hear about in order to grant one of these orders. So first, as I mentioned, there's two main categories, although sometimes they're broken down in three ways. There's the Protection from Abuse Act, which is Title 23, Chapter 661. And then there is the Protection from Sexual Violence and Intimidation Act, which is Title 42, Chapter 62A. So they're different sources of law, but the way the courts handle them procedurally are very similar. But that's we'll get to all the distinctions between the two. But in general, a protection order that you'll get from either of these kinds of cases, it's a civil court order. So it's going to be enforceable through the court, through the police. And the consequences of violating one of these orders is a criminal charge called indirect criminal contempt, which can result in a fine of up to $1,000 and up to 6 months in jail for each violation. So they have teeth to them once you get one of these orders, and we'll talk about the different types. These orders don't cost anything. You just go to the courthouse and you file one, and I'll talk about that process in more detail. Depending on how you filed one of these things, you could either file it on an emergency basis or the regular course of business, which will get you a temporary order, and then I'm going to go into all that. It's going to determine what your next steps are going to be. So if you are, and I'll again also go into the definitions of what is abuse and what is sexual violence. But if you've been subject to one of these things, you would start, depending on if it's an emergency, either by calling 911, or if it's after court hours, your local police non-emergency number, so they can get you in touch with your local district justice. They'll have a district justice on call when the court is not available. And by court, I mean the Court of Common Pleas in Westchester. The district judges throughout the county, they have a rotating schedule where they'll each cover for those off-hour emergency protection orders. So the person who requires protection can get in touch with the district judge on call through a call to the police, 911, or the non-emergency number. They'll file what's called the emergency petition, but they'll lay out what the facts are that have caused them to go to seek protection. And then the district judge will be determined if there is an immediate and present danger of abuse, which will require them to put an order in place until the petitioner would have time to go to the Court of Common Pleas on the next business day to file their petition. The emergency orders, they're going to have the same kinds of protections as you might see in a final order, and I'll go through all those later. But they're going to expire at the end of the next business day. So what the petitioner would have to do, or if it's during the regular business day, or it's not an emergency, they can just go between 8:30 and 4:30 to our Court of Common Pleas, the Chester County Justice Center in Westchester, and they can file their petition there. They go up to the 5th floor of the Justice Center. They have the Family Court Administration Office on the 5th floor, where they'll step up to the window, so tell the clerk that they're seeking a protection order, and then the protection order will match them up with the advocate. They have different advocates from different organizations that cover different days who will help them draft the petition. If they're seeking a temporary order, which I would probably say they should, if they're seeking a protection order at all, they will be brought before the signing judge for that day. They rotate the judges who are responsible for hearing the temporary orders. The petitioner will probably have a very short court hearing with the judge, where the judge will interview them about the specifics of what they wrote in their narrative. They'll write a handwritten statement that says why they've come to court and why they're seeking protection. And then the judge, after reading through that, will either grant a temporary order or deny a temporary order. Either way, they're going to get a court date that's going to be 10 business days from the date they go in and file. And on that court date, they're theoretically going to have their hearing seeking a final protection order. The different protection orders they all start through the same process, whether it's the PFA or the PFSVI. So an emergency one, they go to their on-call district judge with the police. If it's during regular business hours or they've already gotten an emergency order, they'll go to the Court of Common Pleas the next business day to file for their temporary order and get their hearing date. So just going into the different acts themselves now, because they sort of diverge after that initial procedural step. I wanted to start with the PFA Act. It's been around longer. I think 1990 it's been in effect and has a lot of case law, and we're pretty familiar with it compared to the Protection from Sexual Violence Act, which is only a few years old at this point, but we're going to talk about both. So who can file for a protection from abuse petition? It's an adult or emancipated minor, a parent of a child, or a guardian of somebody who they're in charge of because they've been declared by the court to be incompetent. That's just getting them in the door. So who can file this petition? Any of those people on behalf of those people. But in order to take the next step in the PFA process, they have to have the proper relationship. So PFA in particular is only between family and household members. So family and household members is defined by the PFA Act. So you're going to be looking at spouses, former spouses, current or former sexual or intimate partners, people related by blood or marriage. They call it consanguinity or affinity, but it just means blood or marriage. Siblings, in-laws, all those people are the appropriate people to be filing for a protection from abuse if they've experienced one of the defined terms of abuse. I wanted to mention here, I made a note for myself to mention. So among the relief you can ask for is possession of a marital home. If your spouse is filing, there's different rules for where you file one of these things. In general, you can file where the abuse happened. You can file where the plaintiff lives or where they work or where the defendant can be served their paperwork. That's the rules for venue of what court is the right court to hear one of these cases. But if you have a case that involves like a marital property, you need to be filing in the county where the real estate is located. So that you got to go to the where that real estate actually is physically located in order to file your PFA if you're seeking possession of the home as a part of it. So the hearings themselves, like I said, you're going to get a hearing within 10 business days of filing your petition. At that hearing, you're required to present your petition to prove by a preponderance of the evidence that one of the 5 definitions of abuse under Pennsylvania law has happened to the plaintiff, and therefore the judge would have authority to grant an order if they believe that granting that order will bring about the cessation of abuse. So I wanted to start by going through these definitions, and I can go through them sort of one by one. Some of them we have the obvious cases, and then others are tougher for judges to consider. But the first definition is kind of the classic example of abuse. It's the defendant has intentionally, knowingly, recklessly caused or attempted to cause bodily injury, serious bodily injury, or a number of enumerated sex crimes. So in that case, it's the black eye, it's the bruising, so the defendant has done something that has left a mark. Bodily injury is a defined term. It's impairment of the physical condition or or substantial pain. So it doesn't have to leave those bruises. It can be they grabbed their hair and pulled their head back and it hurt real bad. That can meet the definition as well. But the obvious easy case is like the black eye. But you're never going to get those cases. Oftentimes they're more murky. But you're looking for the defendant has done something that shows that their object was to cause that injury, or they didn't care what happened, so long as they accomplished what their objective was. If I have to go through you to whether it causes injury or not to accomplish my goal, I'm going to do that. The idea of recklessness. And when we get through these sections, please feel free to ask questions about these, because the situations vary so widely between the people who are seeking protection that each one really needs to be considered individually to see if it meets one of these. But moving on for now, the second definition is the defendant has placed the petitioner in reasonable fear of imminent serious bodily injury. Serious bodily injury is also a defined term. It's defined by the Crimes Code. It's creating a substantial likelihood of death, disfigurement, long-term disability, severe pain. Those things are going to be the examples of serious bodily injury. So you're in that situation. You're looking for also the idea of imminence. So it's about to happen. They're winding up to inflict the injury. They're pointing the firearm at somebody. Those are going to be the cases where you can feel pretty confident to say that I'm about to be seriously injured imminently. The third definition is the infliction of false imprisonment. So that's depriving somebody of their liberty, tying them up, holding them down, locking them in the closet, restraining them in the subway so that they cannot get away, or making it physically unsafe for them to get away. The fourth definition is the definition of child abuse under the Child Protective Services Law, and that the PFA refers you to the CPSL, which has a list of about 10 different definitions of child abuse. Obviously, inflicting bodily injury on a child, but also creating serious mental injury, creating serious likelihood of injury to a child. Specific things like kicking, biting, burning, stabbing a child can all constitute child abuse. There's a lot of room under Pennsylvania law for parental discipline. So long as it's got a legitimate disciplinary purpose, the defendant may have a defense. You don't these cases come up where somebody says this discipline, this idea of discipline is too extreme. Those are the cases you really have to look closely at, because discipline does have limits. Under Pennsylvania law, parents have been permitted to do things like discipline a child with a belt. But if they're trying to terrorize the child, or if they're trying to inflict that injury, that's going to cross a line and no longer be a legitimate discipline, which would be a defense to one of these abuse cases. And it can cross the line and be found to be abuse. So that can be a tough one too, because where is that line? It isn't always clear. And the fifth definition of abuse is knowingly engaging in a course of conduct, including following another person without proper authority, that places that person in a reasonable fear of bodily injury. So you could look at that as the definition of stalking, but it's not limited to that. It can be any kind of behavior, a pattern of behavior that is building to some point where the petitioner feels that they're no longer safe. So some legitimate actions can cross the line. Oftentimes, you'll see firearms as a part of these cases. One of the I guess you could call it a seminal case in protection from abuse law was a husband who would clean and cock the gun within earshot of his wife and make side comments that placed her in fear. So while he wasn't directly threatening her, he never pointed that gun at her. This pattern of behavior over time, he knew what it was doing to her, which is an important part of the fifth definition, is that the defendant knows that what they're doing is making the petitioner fearful, and they do it anyway. So in order to be successful at the hearing, you have to prove one of those 5 definitions of abuse. It pretty much all boils down to something physical has happened, or there's been some threat of something physical going to happen. The hearings themselves can go a lot of different ways. Because if you don't go to the final hearing, put your case on in front of the judge, sometimes there's opportunities to negotiate with the other side. So agreements in PFAs, they can be anything from they agree to the entry of a final order, which can have all of the relief that would be after a hearing where a judge decides, or you can go the other way and agree to something temporary, where if the defendant complies with something that maybe the judge wouldn't have authority to order under the PFA law, but the defendant is willing to agree to because on the long term it will bring about the cessation of abuse, which is the point of the act, then that's going to accomplish the goal. So maybe we would see an agreement for a temporary order to be continued for a period of months. The defendant would agree to engage in some kind of a drug rehab or mental health therapy, and there's abuser intervention programs that are out there. Something that where the goal of it is that by accomplishing this, rather than just severing all contact, we're going to hopefully remedy that problem. Sometimes it works, sometimes it doesn't. If it does, that's great. Usually it makes most sense to try that in the cases where there's going to be a reason for them to have a connection, like there's kids involved, and now you've got a number of years where they do have to interact in some form, and you want to do it in a safe way. So if you can tackle the alcohol problem because there was some big blow up that maybe is at the line of a PFA, and they'll go get therapy and agree to follow the temporary order for a period of time, and that's going to accomplish the goal. Let's do that. Besides agreements, whether it be for a final or for a temporary order, there's lots of reasons these cases might be postponed. Besides that, so criminal charges are a big one. So often when there's an abuse, there's going to be some accompanying incident that may have led to criminal charges. The defendant, our judges are cognizant of their right not to incriminate themselves in those cases, and therefore all the defendant has had to do is ask, and they'll be granted a continuance to deal with that criminal case first. So if somebody's trying to file or has gotten a PFA, it can be frustrating, but it happens all the time. And the request we always make is that the temporary, and the court's really good about it as well, is that the temporary order would remain in effect so that they aren't prejudiced by being exposed to new abuse because the case is postponed. Other reasons for continuance, the defendant has an automatic right to a continuance if they're served. I think it's like within 3 days of the hearing. The judges will also always give a defendant a continuance if they want to go consult an attorney. You have a right to be represented by an attorney at one of these hearings. You don't have a right to be appointed an attorney. You don't get a public defender or anything. So if somebody wants to go out and consult or hire an attorney, the judges will give a continuance for that reason. So I talked about continuances, agreements. I want to talk about, before moving on to the protection from sexual violence orders, there are types of relief you can get under one of the under PFA, under the PFA Act. So in general, all the PFA orders are going to say that the defendant shall not abuse, stalk, threaten, harass, or place the plaintiff in fear of further abuse. That's going to be the general one. But then the rest of the order, they have a number of forms of relief that they can order. So a big one, the second, probably most common one, is the eviction or exclusion from the home. So if, as I mentioned before, if it's a marital home, you're filing in the county where your home is located. If you're married and there's a duty of support, the court can order the home be awarded to one spouse. If the parties are leasing, or either jointly or solely by the plaintiff, they can award the leased property and evict the defendant from that property as well. So that's pretty common in these things, is that you'll see a home awarded to the petitioner if it's either they're on the lease or if they're married to the defendant. They can order no contact. That's probably the next most common one. And no contact, it's divided into two parts. No contact means no contact verbally, text message, social media, smoke signals in the sky. Really, any kinds of communication whatsoever is going to be prohibited. So liking somebody's post has been considered contact on social media, and that's caused violations. Giving somebody a hard stare from across the courtroom has been found to be contempt and has caused somebody to be violated for the order. So no contact is very broad, and it's often the way that people slip up on these things is they'll send the text or they'll respond to a text. These orders don't go against the petitioner; they only go against the defendant. But the petitioner can certainly, if they're sending a text message, be putting that defendant in a position to violate. And they don't also, as a petitioner, you don't want to muddy the waters for enforcement purposes by causing the defendant to have reasons to reach out to you. But anyway, contact is a big way that people slip up on these things and get violated. Contact also means contact at locations. So we don't have like a stay 50 feet away, but we have a no contact at your school, your place of business, your church, really any location where you might be found. You ought to just turn and walk the other way. Because that's again a way that people violate these things. Questions come up when there are kids involved and they have an activity where you're going to be in the same auditorium or in the same sports field. What I would usually tell people is that, first of all, the defendant ought to have no contact whatsoever with you, but just being there isn't in itself going to be the violation. They ought to be staying on the other side of the field or the gym or whatever it is. But just being there isn't in itself going to be a violation. Now, if they start causing problems, the protected person should call the police. But otherwise, contact is one of the big ways that the defendants can find themselves in trouble. Another big one is temporary custody of children. As a part of a PFA order, the judge, whether it be as part of the temporary order process or after a hearing for a final order, can award temporary custody of kids to the petitioner. What they're not going to do is disturb an existing custody order. So if the parties already have an order in effect, they're not going to go and flip that custody order unless the petitioner is alleging there is abuse of the children and the court finds after a hearing that there's something to that, and therefore the court needs to step in to stop that. But in general, they're not going to go and change the custody order. They're not going to flip custody just based on the petition. The judge is going to have to be convinced that there's a safety concern. That doesn't mean that they can't put in safety provisions for temporary custody. So maybe you do have an existing custody order and you found it necessary to file a PFA, but you no longer want to exchange at the other person's residence. So we could do an exchange, maybe curbside. The judge could order something like that. We do it at a Wawa or some other public place with cameras, or we use a third person. So safety planning for exchanges could be on the table, but in general, they're not going to go and just stop the custody order, deny contact again, unless they think the defendant is going to be a safety risk to the child or is going to flee the jurisdiction with the child. Something along those lines. In that case, they're not going to order any kind of unsupervised contact between the defendant and child. And if the allegations of abuse are serious enough, then the court is going to say no contact whatsoever until this is dealt with in a full hearing, and then whatever is decided as a result of that. Another thing that the court can order, although we don't see it too often, is temporary support. If you do get temporary support as a part of a PFA, you're required, or else it expires, to go and file for your regular support petition within 2 weeks of that. And you file them at the same place. So you can just go down to the third floor so you start on fifth floor where you get your PFA, and then go down to the third floor and file your support. And they have a self-help window there where they have packets, and you can file there. But you can get it as a part of a temporary order, and it might, in some circumstances, be really important if there's a duty of support and the rent's due, and the rent payment is going to result in an eviction filing or something like that by the landlord. Then maybe in that case it would make a whole lot of sense to ask the judge to direct that the defendant continue to make that payment until such a time as you can have the full support hearing. But it's all going to be based on the extent the parties' support obligations are calculated. So it's going to be it isn't going to be like they have to pay the whole amount or anything like that. It's going to be a calculation. They can also order medical coverage continue, health insurance coverage continue for a spouse or child. They can order unreimbursed medical expenses be paid, but all these things you can get through the regular support process. So that's where you ought to want to be. Firearms. So the temporary and final orders is mandatory if a judge hears a case and enters a final order. But otherwise, the defendant can be ordered to be prohibited from possessing or acquiring firearms for the duration of an order, and they would be directed. And this is any firearms that's under their control. So if they've got like somebody else's guns in their house, they might have to surrender those too. But they would be required to relinquish them to the sheriff or law enforcement or an armory within 24 hours of the entry of an order that directs them to surrender them. Reasonable losses. That's another category I just dealt with recently. So if the defendant has caused property damage as a result of their actions, they've caused real property damage, personal property damage. If they've caused medical or dental expenses, relocation expenses because a person is displaced from their home as a result of the abuse, the court can order these things be reimbursed if after a hearing they find abuse occurred and that these things are the reasonable losses attributable to that abuse. In addition, just a couple more of the different relief things. They can direct the defendant be prohibited from stalking or harassing your household members. So if you've got maybe parents in your household and the defendant reaches out to them, and that reaching out to them crosses the line to become harassing, which can become harassing as easily as saying, please don't contact me, and they continue contacting you. It can also be a violation of the PFA to do that, to commit that harassment. Harassment would be an independent crime, but it would also trigger a PFA violation for this person to be harassing your household members. And then anything else the court believes is appropriate. And what that can be, we don't really see that too much. Usually we're going to be on the no abuse, eviction, no contact part of it. And then next would be the temporary custody and firearms provisions. So that is the protection from abuse. And I wanted to turn now to the Protection from Sexual Violence and Intimidation Act. So when I talk about the PFSVI Act, it branches out into two different things. So there's the protection from sexual violence, and then there's protection from intimidation. So when we talk about protection orders, I said there's two, but there's really three. They just come from two different sources: the PFA Act and the PFSVI Act. So the PFSVI Act is kind of the opposite. Although a lot of the procedures are identical, you go to the fifth floor, you file your temporary order, you get your hearing in 10 days. At that point, it's going to diverge. And importantly, it's who could file one of these things is one of the ways that these diverge. So the family and household members who are entitled to file for protection from abuse orders based on abuse between one another, it's the opposite for protection from sexual violence, intimidation. These are people who are not family or household members. So these are going to be maybe coworkers, neighbors, strangers, people you don't know. It's going to be the opposite. And importantly, another important distinction is the protection from sexual violence. It's the same people can file one of these things: an adult or an emancipated minor, a guardian on behalf of their ward, a parent on behalf of the child, but also household members can file on behalf of the child as well. So if an adult relative needs to file on behalf of their granddaughter or niece, nephew, they would be able to do that. That would probably come up if one or both of the parents were the perpetrators of the sexual violence or intimidation. So unlike the sexual violence, which it can be anybody who is not a family and household member against that stranger, the protection from intimidation is only a minor victim. So the victim is under 18, and the perpetrator, the defendant, is 18 or older. And then the definitions of sexual violence and intimidation are going to differ as well. What you also has to prove at one of the hearings is also significantly different than under the PFA Act. The PFA Act, I said you have to prove one of your 5 definitions of abuse. Under the Protection from Sexual Violence and Intimidation Act, you have to, at your hearing, first assert that your client, your plaintiff, the petitioner is a victim of sexual violence or intimidation, and then prove that the victim is at a continued risk of harm. So it's a sort of a 2-step process. And then starting with sexual violence, I'll talk about what the different conduct constituting these offenses are. So points to the protection from sexual violence part of it, points to the crimes code when it comes to sex crimes. So Chapter 31 are your sex offenses like rape, sex assault, those types of crimes. It's all going to be covered. Sexual violence is also going to include endangering the welfare of children when the conduct includes sexual violence towards a child. It's going to include corruption of minors, damaging the morals of the child you're in contact with, sex abuse of children, unlawful contact with a minor, and sexual exploitation of children. So these are going to be looking first to the crimes code, these definitions, and you want, as the advocate, as the attorney representing them, you would want to make sure that every element of that definition of the crime is hit. And then the next step would be convincing the court that this person is at a continued risk. And there's been cases that have come out that say that this is not just the risk that the perpetrator is going to do something new to the victim. It's the psychological well-being of the victim if they're going to see this person at the community. The case I'm thinking of, it was they were at a school, usually the high school or college, and they were still going to see each other at the games and the classes, and this was causing the victim a lot of fear, having to see this person around. And the court said it's about what this victim is experiencing, not whether he's going to do something new to her. The continued risk is that she's going to be harmed because of this exposure, and so it was able to grant an order based on that. Turning to intimidation, so that as I said was between the adult perpetrator and the minor victim, and it's going to look also to the crimes code for its definitions, and in that case it's going to look to 4 definitions of harassment, so A4 through A7. So communicating to or about a person, lewd, lascivious, threatening, obscene words, language, drawings, or caricatures, communicating to a person, the child in this case, anonymously, extremely inconvenient times, or repeatedly in some other manner as than what I just specified. So I've seen cases where this would be like on the Xbox messages or something like that, where they're reaching out to them and saying something over and over for no good reason. Usually it's something offensive or derogatory. The relief, if the court finds that the victim is been a victim of sexual violence or intimidation and is a continued risk, can then open its toolbox and order the relief that it has under the Protection from Sexual Violence Act, which is excluding them from the plaintiff's residence. They can't show up at their house, prohibiting all contact between the victim and the perpetrator, and then any other relief the court thinks is appropriate. So it's not as broad as the different things that are available under the PFA Act, but the goal is that they're going to sever all contact between the perpetrator and the victim, and then hopefully that will be effective in stopping whatever the conduct was that was causing the victim to seek protection. So what does somebody do if they find themselves in a situation where they need one of these protection orders? Well, first you want to report the conduct to the police. If it's an emergency, you call 911. If it's a non-emergency, you call your local police department, whoever would respond if when you call them, and report and ask to speak to an investigator or an officer who can handle it. It would be hopefully they would charge the defendant with something. But if nothing else, they could give you the information about if there's an emergency district justice on call, and they'll probably advise that the victim go and file for a protection order of some sort at the Court of Common Pleas on the next business day. Once somebody is filed for a protection order, they can come to legal aid, and we can represent them at their hearing. We treat these as emergencies, so rather than going through our telephone intake unit, which was where most of our cases begin, a person seeking protection should, if it's in Westchester, just call our local office. Number is 610-436-4510. Explain that they just filed for a protection order and they'd like to bring it over. The number for the rest of our cases, if they just need help with a civil legal issue, it's 1-877-429-5994. The other organization in Chester County that handles protection order cases is the Domestic Violence Center of Chester County. Their number, they have a hotline, 888-711-6270. And then once somebody is become involved in this process. Hopefully we've been able to help them get involved, and we've gotten involved with their case. But the person can also contact our victims assistance organization in Chester County. It's called the Crime Victims Center of Chester County. And their number is 610-692-7273. And they offer counseling. They have advocates that can go with the protected person, either the PFA court or the criminal case, if there's an accompanying criminal case as well. Fantastic organization to be involved with. So everybody who's got one of these going on should get in touch with them and get the advocates to go with them. Yeah, that's my presentation. I open it up to questions. I think we're good for time.
Yes, Brian, would you be able to type those phone numbers into the chat so people can see them?
I don't have a keyboard.
Oh,
I'm on my
okay.
tablet.
Oh, wow. Okay. All right, let me stop the recording. Anyway, thank you, Brian. That was very, very exhaustive and thorough. So let me stop the recording so people can ask questions.